Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am a third year student of BBA LLB from Bharati Vidyapeeth New Law College, Pune. And for the today's topic is Doctrine of Colourable Legislation, and the purpose of this video is to create awareness about this topic. So I will start with a definition. India has a federal form of government and has been a united country for over 7 decades, with power being divided between the center and states on the account of federal structure of governance. The federal form of government has two or more levels of government. Each level of government has its own jurisdiction. The jurisdiction of the respective level of government is specified in the constitution. The main feature of federalism is the segregation of power between the state and the center. The fundamental provisions of the constitution cannot be unilaterally changed by one level of government. Federal system has the objective to safeguard and promote unity and accommodate regional diversity. There was consensus on power sharing even before independence. Leaders were aware of the regional and linguistic diversity. The Constituent Assembly decided to form a government that would based on the principle of unity and cooperation between the center and the state, which was to have constitutional status and a clear identified area of activity. However, if a legislative body isn't allowed to make laws in a particular area and does so anyway, indirectly under the grab of another legislation, the doctrine of colorable legislation comes to play. The doctrine of colorable legislation is applied to see whether they are competent to enact the specific law or not. Though so separation of powers means dividing or sharing of powers. In order to prevent the misuse of power by any one organ of the government, the constitution says that each of these organs should exercise different powers. This develops a system of checks and balances. The constitution has divided powers between the center and the state with their particular subject matters, but sometimes the legislative body enacts legislation which falls outside its area of competence. This means that it has transgressed its power and has directly done something which could not have been done directly. This is called colorable exercise of legislative powers or indirectly making laws when prohibited from doing so directly. So, to check the transgression of legislative authorities, the doctrine of colorable legislation comes to exist. Article 246 of the Indian Constitution is about subject matter legislation, referring to who has the power to regard to which subject to which to make laws. We know that the power has been distributed under the three lists. The powers of the center and states have been categorized by the seventh schedule under three lists: Union list, list 1, state list, list 2, and concurrent list, list 3, which is mentioned under Article 246 of the Constitution. If the legislature make laws or under guise on a subject without having required competency to make laws on that particular subject, then the Supreme Court can invalidate the entire law. Colorable legislation come into question when there is a question of competency of a particular legislation to enact a particular law. It challenges the accuracy of an enacted law with regards to the body that passed the law and analyzes whether the legislative body has the power to make laws on that subject or not. In case the legislator is not competent on this said subject, then the law is said to be ultra vires. When a legislature makes a law which appears to be within its authority, but in reality it is not, then the law would not have any validity. Even though a color is given to the law for bringing it under competency, it would be declared as void. Colorable legislation emerges whenever the legislative bodies has had no power to create laws on an item because either it was not included in the list as per Schedule 7 for the limitations of Part 3 of Constitution or any other provisions of the Constitution. When the legislature indirectly disobeys the terms of the Constitution and claims any act to be written within its power, then it is a fraud on the Constitution. Colourable legislation suggests an encroachment on the legislative power. The doctrine of colourable legislation strictly prohibits doing indirect things when it is not allowed to do so directly. It tests whether the legislator has enacted a law as per its authorized competency or not. So, whether there is a restriction to make laws, the legislator has to follow the same, otherwise, it will be declared as ultra virus of the legislative powers. If any law is made out of any guise, then the colourable exercise would be imposed on legislative authority. Legislative authority is the body which legislate laws. They are elected by the people and work on behalf of the people. The doctrine of colourable legislation acts like a check on them, and if it finds incompetency, then the law becomes invalid without there arising a need to determine its necessity and requirements. It only checks the competency of lawmaking body and restricts overstretching powers. As this doctrine doesn't check whether the law is mala fide or bona fide and only examines the competency of its legislative authority, it becomes an impediment to the functions of legislative authority. Thank you all of you. That's all for the topic. Please like and comment on the video. Thank you.